All right, this is case number 2165615. This is Affiliated Diagnostics of Coleman versus City of Detroit. Your appearance at this time, please, for the plaintiff.
Good morning, Your Honor. James Law on behalf of the plaintiff. My P number is 63110. Thank you, Your Honor. My opposing counsel called me. He was here. He called me and said that he had another settlement conference at 10 and one at 10:15, and to tell the court that he would be back.
All right. So have you guys got this worked out, or what's going on?
We have not yet. We started to talk numbers this morning. I asked counsel if he would be amenable to sending this to case evaluation since we seem to be a bit apart. I didn't get an answer one way or the other back whether or not he'd be amenable.
All right. So I'm going to set this aside for a moment. I'll come back to it. We'll address it along the way. Thank you very much, sir. Appreciate it.
Thank you, Your Honor.
The court is calling case number 21-156567. This is UHG1 LLC versus James Ashley. The matter is before the court set on for a hearing on today's date. I do see that there was an answer filed. I see that there is also a motion for summary disposition. I don't know that there was a scheduling order in this matter previously. We'll check all that out now. Your appearance for the plaintiff at this time, please.
May it please the court, Your Honor, Jeffrey Beers, P41693, on behalf of plaintiff UHG.
Thank you, Mr. Beers. Good morning to you. For the defendant in this matter, your appearance at this time, please.
James Alley.
And Mr. Alley, your P number, if you will, at this time, please. Oh, sorry, I had you mixed up with a lawyer that has a similar name. All right, so you're not a lawyer, is that correct, sir?
No, I am not.
All right, thank you. I did receive your answer regarding this matter. I've also received a motion for summary disposition that's been filed by the plaintiff in this matter. Did you get a copy of that motion, Mr. Alley?
That one, right there,
Which one?
the big one, that one.
Yes, yes, Your Honor, I did.
All right. And I don't see where you filed any written response or anything to that motion, correct?
I'm sorry.
I don't see where you filed a written response to that motion. Is that correct? You did not file a written response.
No,
No, I did not.
All right, just one moment. Let me go to Mr. Barris. Mr. Barris, tell me a little bit about your motion, sir.
Yeah, this case is for a non-payment of a loan through Lending Club Corporation Web Bank, which was assigned to UHG1. In his answer to the summons and complaint, he stated he did not know the answer to all of the paragraphs, and that he has a debt settlement company, Freedom Debt Relief, that's working out payments with different other creditors. We filed our motion for summary on December 14th, and we're just waiting for a date on that.
I got you. All right, so you understand the nature of the motion for summary disposition regarding this matter, Mr. Al. You understand, sir?
Yes.
All right. So it sounds like, and you know, I can set it for a date for formal hearing on this, but it sounds like that this is a debt dispute. But it doesn't seem like it doesn't sound to me that there is a real significant contest as to whether or not there is an indebtedness. I mentioned that not to say that that is in fact true. It just seems that way. But I also mentioned that because this might be a good juncture at which the parties could talk about this and see if there is a way to reach an accommodation as to if there is a debt owed, as to amount, and as to a strategy that would allow for payment over time. Is that something that sounds like it might make sense as a starting point to talk about, Mr. Alley?
Yeah, I wouldn't mind having a conversation with him about it. I don't know if this is the time to explain to you any part of what's going on.
No, I can't get you. I can't let you explain to me.
Right. I'm a truck driver, so.
Gotcha, sir. All right. So what I'm going to do, Mr. Barris, is I'm going to put the two of you in a breakout room to talk about those specific things. and to see if you can reach some type of accommodation. If not, we, obviously, there's a process for going forward in this matter. But oftentimes people are able to talk about it a bit and say, well, I think it's this number instead of that number. I'm willing to compromise at this amount, et cetera, et cetera. And then sometimes they can reach an accommodation as to how the matter might be resolved going forward. So I do believe that that is worth the conversation. Nobody is bound to constrain enforcement to a position, but it's worth the conversation. So I'm going to send you a notification, Mr. Alley, for breakout room number 1. And the attorney is going to meet you there. And then I need you to click back in once you have a chance to speak. I'll get right back to you. And we'll see which way we go forward from that point. All right. So you receive your notification, Mr. Alley, and counsel, I'm looking for you. And I'm going to get that notification to you in just a moment, sir. And there you are. All right. I'll speak with you guys.
Thank you.
Short.
Thank you, Your Honor.
Thank you. Good day. The court now calls case number 21-161-349. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance Company. Matter is before the court, set on for a pretrial conference on today's date. I believe that having received a answer to the complaint, well, actually, I'm looking a little bit further. It looks like the court also set a scheduling order. That scheduling order, I had to correct something the last time that the parties were here, and then I reset it for today's date. Your appearance for the plaintiff regarding this matter, counsel.
Good morning, Your Honor. Sandra Toma appearing on behalf of Michigan First Rehab, P number 84575.
Thank you, Ms. Tolman. Good morning to you, ma'am. For Nationwide Mutual, your appearance at this time, please.
Good morning, Your Honor. Dan Gupta on behalf of defendant Nationwide, P82748.
All right, thank you, counsel. Good morning to you as well. All right, so I know that the matter has been joined. I know that I set a scheduling order on a previous occasion. I know there was some confusion regarding address at one point. Somebody update me on this matter at this point.
Your Honor, defense did serve us with discovery. It's been answered. We have sent it back over. And at this point, it's just, I mean, I don't know if defense would like to go to case eval, but we are open to that on our end.
All right, sounds good.
Good morning, Judge. Hi, this is Precious Smith, chiming in for Mike Fortner. He's pulling a jury in Highland Park this morning. He's on the Robert Newell matter.
Oh, okay, I'll come back to that. I'm not on that case right now. Thank you.
Okay.
I'll call that shortly, and then you'll be able to note that. And don't
Okay.
interrupt me. It's good to see you. Happy New Year to you.
Good seeing you, sir.
All right. Oh, wow. I thought it was a third party coming in here. I'm like, wait a minute, what's that?
Oh, okay. So I wasn't sure if you was on his matter or not.
Not a problem. We'll come back to that.
Okay.
Okay. So for Nationwide, what do you think? Have the two of you had a chance to kind of talk this out a little bit? Obviously, a third-party engagement in terms of mediation, that kind of thing always sounds reasonable to the court. Have you tried talking about it at all to see if a discussion might lead to being able to narrow what the issues are and perhaps draw you closer in terms of being able to resolve it?
Nationwide isn't necessarily opposed. Sorry, go ahead.
Yeah, we have not spoken, but I'm sure we're both open to speaking about coming to a closer resolution.
Counsel, you were saying something?
And I would just note for the court that Ms. Wilson has her own suit that's also currently in front of Your Honor. And in that suit, we have her deposition scheduled for February 24th, this year. So I think maybe after we are able to secure her testimony, we will have a better idea of the claim and what some of the issues are. And I think maybe after that, if we feel case evaluation would be beneficial, that maybe we would go that route at that time after we secure her testimony. Yeah,
certainly. If you've got something outstanding as big as the as the testimony of Ms. Wilson, who's the primary claimant here, yeah, that would be an important component. And I think that component might be a critical factor in terms of whether or not the case can in fact be resolved. So yeah, I think what I'll do is I'll go ahead and grant the courtesy of an adjournment finding good cause for the same and set the matter over beyond the date for the deposition in this matter. That does not prevent the parties, of course, from engaging and trying to figure this out along the way. I will certainly encourage that. So what I'm going to do is I'll go ahead and set the next hearing date in this matter about 6 weeks out, so the end of February. I'm going to give you.
Well, you said the end of February?
Yeah.
Well, the 28th?
My clerk says the 28th, 2/28, 2/28/22, and that's going to be at 9:45 a.m. 2/28/22, 9:45 a.m. And I'll adjourn it over. I do think that some process to try and work it out is a good thing to do, but that testimony could be a critical part of that. So let's come back on that date, 2/28/22 at 9:45 a.m.
Thank you, Your Honor.
Sounds good. Thank you very much, Judge.
Thank you. Good day to the two of you.
You
Yep,
too.
you also. Thank you.
Did I see Mr. Lowe back in?
I'm still here. We were waiting for Mr. Cunningham to come back.
Okay, he's not. That's what I was checking up on. So you're not seeing him just yet, right?
I haven't seen him yet. If you would just want to put this over for a minute, I'll give him a quick call and see if he's done with his other case.
Yeah, I am. I've got it on hold, so just didn't
Okay.
want you to be waiting if he showed up. So
I
let me know
appreciate
if- Okay. Do I have Mr. Veras back in the Zoom or Mr. Atwood? All right. The court now is looking at case number 21-152234. This is Robert Orthopedic Service versus Liberty Mutual Insurance Company, and I did receive a indication from Ms. Smith that Mr. Fortner, who was on this matter, is in selecting a jury in a pending trial. Let me have the appearance of the defendant regarding this matter. Your appearance, please.
Good morning, Your Honor. Michael Martinico, P75556 on behalf of the defendant. How are you this morning?
I'm good, and good morning to you, and happy New Year to you as well, sir.
Thank you.
Looks like somebody is dealing with pecking order this morning. They have a higher priority type situation where Mr. Porter seems to be in the midst of picking a jury.
Right.
Have you spoken with, have you and Mr. Porter had any opportunity to talk recently regarding this matter?
We have, Your Honor, yes. And Mr. Fortner did text me that he was in a trial. But what our plan is this is going to be dismissed without prejudice. We were talking settlement numbers. He was confirming with his client and understood the bills have increased over the jurisdictional maximum. The patient does have his own suit in Wayne County Circuit Court. So Mr. Fortner is going to represent those in that case. So if we could perhaps push this out 30 days for review hearing again, and we should have dismissal without prejudice documents to you.
All right. And basically transferring this matter over to the.
I don't think it's going to be a transfer. Mr. Fortner does represent the patient in that Wayne County case. So he'll have the bill. So I think it saves him money since he doesn't have to pay a transfer fee, and it's a little bit easier. If he wants to go that route, we can do that. But either way, you're going to get either a transfer order or a dismissal order. So you'll be done with it. And like I said, we just discovered this late yesterday, so we haven't been able to draft the documents yet, but we'll have those to you.
Got it. And thank you, Mr. Percy-Smith, stepping in just to let us know. And counsel has confirmed the situation regarding Mr. Fortner being in trial. I'm going to go ahead and adjourn the matter for 30 days out. My clerk's-
February 15th. February 15th.
That's going to be 2/15/22, 2/15/22, and that's going to be at 9:30 a.m. And I'm adjourning it for review at that time. And
Very good.
I understand the sense of it is that it's likely to be something that is going to be dealt with in another setting. But we'll address that on or before the 15th of February 2022. That's control date at 9:38.
Very good.
Thank you much.
Thank you.
Thank you, Precious. Thank you, Your Honor. Take
All
care.
righty.
Bye now.
Court is now looking to file number 21-160918. This is William Buford and Alice Tillman versus Progressive Marathon Insurance Company and Allstate Insurance Company. The matter is set for a pretrial conference on today's date. The court did issue a scheduling order in this matter, allowing for discovery in this matter through today's date, and also allowing for the filing of motions to be set for hearing on today's date. Your appearance for the plaintiff regarding this matter, please.
Good morning, Your Honor. Helen Cooley on behalf of plaintiff, both plaintiffs, Alice Tillman and William Buford, P number 84581.
All right, Ms. Coley, good morning to you, and thank you very much, ma'am. For the defendant and defendants in this matter for Progressive, please.
Good morning, Your Honor. Hi, Ahmed appearing on behalf of defendant Progressive, P 84620.
All right, thank you, Ms. Ahmed. Good morning to you, ma'am. For Allstate Insurance, please.
Good morning, Your Honor. Reno Erba on behalf of defendant Allstate, P 83692.
All right, good morning to you as well, counsel, and thank you for being here. So this is indicated as the close of the discovery. Update me on where you are. Did you get accomplished what you need accomplished? Let me start with you, Ms. Coley.
Your Honor, we did settle Miss Alice Tillman's case. We're just waiting on closing documents to come from defense counsel and sent to the court.
All right, and is this settlement, does it involve all of the parties here? Well, does it involve Progressive and Allstate, or is this?
No, Your Honor, just as to Alice Tillman for Progressive.
All right, and would that resolve the claim that's before the court, or will there still be some portion of this case pending?
Correct, Your Honor. There will be some portion of the case pending as to William Buford. Plaintiff recently sent the demand out to Allstate, and hopefully we can get that resolved shortly.
All right. Mr. Arabo.
Yes, Your Honor.
Thank you. Just trying to make sure I don't mess the name up. All right, you represent Allstate, is that correct, sir?
That's correct, Your Honor.
So there's some counsels indicated that there was a demand sent out in some effort to try and see if this might get resolved. That's about the size of it to the best of your knowledge.
Yeah, that is true, Your Honor. We did just receive it a couple days ago. I sent it to my client. They're still considering it. At this point, we probably need more time. We just got the demand. Hopefully by next time, we hope that things will be settled by then.
All right, very well. So, Ms. Ahmad, you've got this all worked out, and it's just a matter of paperwork at this point.
Yes, Your Honor. We're getting to submit the paperwork to the plaintiff, and then shortly we'll have the dismissal to the court.
Sounds good. All right, so what I'm going to do is I'll go ahead and adjourn it over for 30 days as a control date. That gives the opportunity for the exchange of documents on that portion that has been resolved. It also gives an opportunity for the plaintiff number 2 and defendant number 2 to see if they might resolve the remaining issue in this case. So I anticipate the stipulated dismissal order relative to plaintiff number 1 and defendant number 1, and then we'll see what happens by the next action date regarding the balance of the claim this year. That date's going to be the February 15, 2/15/21. I'm going to go ahead and set that at 9:30 a.m. and I'm going to set this for review. I'll review everything at that time. All right, thank you very much. I wish you well good day to each of you.
Thank you, Your Honor.
Thanks, Alan.
Thank you.
Mr. Beers, I do see that you're back in the Zoom relative to the suffix 6567. That is UHG 1 LLC versus James Alley. The counsel has previously entered his appearance, and Mr. Alley has noted his appearance here regarding this matter as well. Mr. Beers, if you'll update me at this time, sir.
Yes, Your Honor, we had a good discussion this morning and we're pretty close. We have not completely settled the case this morning. But we exchanged contact information. We're going to continue speaking after today. And I was wondering if we could have a date for our motion for summary as a backup.
Gotcha. Mr. Alley, are you back with us, sir? Or did you get stuck in the breakout room?
Yes, unmute.
Yes, Your Honor, I am. I apologize. I duck out there for a minute. I clicked on the wrong tab.
Not a problem. You made it back. There are many that can't.
Yeah, I had to actually call my son down to get me back on this.
All right, perfect, sir. So you guys had some discussion. The case is not resolved. I'm going to go ahead and set a date. That would be the date for the hearing on the motion for summary disposition, but it also gives interim time for the parties to continue any discussions in an effort to try and get this resolved. So I'll go ahead and set it over for the 15th of February, 2:15. That's going to be at 10 o'clock a.m. 2:15. 2022. And that is formally set as a hearing on the motion. And of course, the court will review the party's progress. And if you're able to get it resolved, then Mr. Barris will give some direction as to how this, how to end this up. Order can be submitted to the court resolving the case, and that will control things from that point. Otherwise, I'll see you on the 15th of February at 10 o'clock a.m.
Thank you very much.
Thank you.
Good day to the two of you. Thank you for your patience.
Have a good day.
All right, Mr. Law, I see that you're there. We're still waiting, correct, sir?
I see that Mr. Cunningham has come back.
All right, very well. Thank you. All right, and so we're back on the record relative to 5615 Affiliated Diagnostics Oakland versus City of Detroit. And I called this earlier, and of course, Mr. Cunningham had other cases, and I appreciate his return at this time. And Mr. Cunningham, you will formally your appearance for the record at this time, sir.
Yes, Your Honor. Patrick Cunningham, my P number is 67643. I apologize for bouncing around between courtrooms.
Oh, not a problem, sir. Thank you, Mr. Lowe, as you previously entered his appearance under P63110. All right, so where are we regarding this matter? I know I'm moving along kind of fast here. Go ahead and kind of update me a little bit.
Your Honor, Mr. Cunningham and I briefly talked numbers this morning. It seems that we're far apart. My suggestion would be that now that we're past the motion for summary disposition, if the court would be inclined to send us to case evaluation, I think that would be helpful to bridge the gap between our two sets of numbers.
Mr. Cunningham, what are your thoughts in that regard?
Your Honor, I can't agree to case evaluation. I don't know that Mr. Lowe is wrong. That maybe is not wouldn't be useful, but I just think we're pretty far apart, Judge.
Got you. All right. So, it's one of those kind of things where it may help, it may not be helpful, and the only way that we'll find that out is to do it. So I'm going to go ahead and issue an order consistent with sending the matter over for a case evaluation, and I'll set this case over for a review hearing after that. And of course, nobody loses anything. Perhaps we lose a little bit of time, but nobody loses anything by that process. And so I'll go ahead and set it. I'm hopeful that we can get it in and back here by the end of February. Am I being overly optimistic, Mr. Lowell, Mr. Cunningham?
I think that's probably a good time frame, Your Honor.
All right, so I'll go ahead and set it over for the for 2/28. 2/28/22, and I'm going to set that for 9:45 a.m. I am setting it as a review hearing, and I will issue an order, and you'll receive it from me. I'll have it done today, so that you can engage in a process for having this evaluated or mediated, whichever way you choose to go out. So I wish you well. And I'll see you on the 28th. You'll get the order from me in short.
Thank you, Judge.
Thank you very much, Your Honor.
And I apologize, Mr. Lowe, for making you wait.
No, no problem, Mr. Cunningham.
All right, the court now calls case number 21-240778. This is Christopher Wolford versus KMG Prestige Incorporated. The matter is before the court. Looks like set on for a first hearing after the filing defendant's answer regarding this matter. The court would indicate that this started out before this court as a small claims matter, alleging damages of $6,500. The matter was subsequently removed to the General Civil Division, and the matter set for a scheduling and status conference on today's date. Your appearance for the plaintiff in this matter, please.
May it please the court, Mark Wasbury, P51575 for plaintiff. Excuse me, Your Honor, defendant. I'm so used to saying plaintiff. I'm here for the defendant today, Your Honor.
All right, you jumped the gun a little bit. Good morning to you, Mr. Wasbury. It's good to see you, sir.
Nice to see you.
For the plaintiff in this matter, if you will. Do I have Christopher Wolford or counsel representing Mr. Wolford in this matter? All right, I'm looking for Christopher Wolford, a person residing on East Hancock Street in the city of Detroit. If you are present, please say something at this time. Record should reflect that the matter is set for 9:45. It's now 10:43. I'm looking once again for Christopher Wolford. I do see that the notice from the court went out with the correct Zoom address. Just one moment, counsel. Yes, providing a defendant with adequate information as to where he should appear. And Mr. Wasbury, that's how you were able to find your way into this particular spot. Is that correct?
That's correct, Judge. We received notice from the court. I'm standing in for Mr. Gann, but he was well aware of this date.
All right. So given that the defendant has not appeared, has not otherwise contacted court, striking the plaintiff has not appeared, not otherwise contacted the court regarding this matter. Just a moment. And no explanation for the non-appearance. The court at this time will dismiss the complaint where the plaintiff has failed to appear. So ordered at this time.
Thank you, Judge. I will present a dismissal.
Thank you, counsel. Good day to you.
You too.
All right, this is case number 21-169-897. This is Tox Testing Labs versus City of Detroit. The matter is before the court set for a hearing on today's date. I did receive this case by way of change of venue. And I believe that this is the first hearing after change of venue regarding this matter. Your appearance at this time for the plaintiff, if you will, please.
Good morning, Your Honor. Michelle Khan appearing on behalf of the plaintiff.
All right, Ms. Khan, your P number, if you will, for the record, please.
Yes, Your Honor, P75585.
All right, thank you, Madam Counsel. Good morning to you. And for the city of Detroit, your appearance at this time.
Good morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of defendant City of Detroit.
All right, thank you, Ms. Cobbs, and good morning. Happy New Year to you. Ma'am.
Happy New Year, Your Honor.
I know that this is just up in the city, but it looks like I've got a file that was turned over with quite a bit of information. There was a motion for summary disposition, et cetera, et cetera, et cetera. So where are we at this point? Somebody kind of.
Judge Coleman, may I speak? And there's two other attorneys who are appearing today. You may want to gain our appearances before we go further.
On this case, I'm dealing with tox testing versus City of Detroit at this point.
Yes. Yes, Judge, if I may speak, I'm now this is why we're here, and we all have talked beforehand, but this was a transfer. By the way, my name is Tim O'Connor. I represent MAIPF. My P number is 40517. You are correct, Judge. This was a transfer from the 15th District Court to Your Honorable Court in the 36th District. Michelle Kahn being the plaintiff. We've got Mary Beth Cobb representing, I believe, is it Smart?
City of Detroit.
City. And then Brian Kingsley, you may want to hear from him, who represents Smart. When the case was transferred, Judge, although the MEIPF did file an answer, the transfer order, when I looked at it, did not have my client as a defendant, MEIPF. So on the Register of Actions, you do not show my client as a defendant, although we should be. Also on the Register of Actions and on the transfer order, it identifies that our firm represents Smart, which is incorrect. And I think the parties will tell you that there is some confusion that we hope to remedy, but we want to bring it to the court's attention.
So it seems to me, and I'll come to you, Mr. Kingsley, in just a moment. It seems to me that the first thing that we kind of need to do is to align the parties in their respective opposition. It seems to me that there are three defendants herein, but when the transfer order came over, it did not recognize the three defendants, of one being the City of Detroit, the other the assigned claims facility, and then Smart. And it also seems like there might be a misalignment of the attorneys in relationship to the various defendants. So, Mr. O'Connor, I get that you are entering an appearance with regard to Michigan Automobile Insurance Placement Facility, correct, sir?
Yes, I am.
All right, and Mr. Kingsley, I'm going to take a wild guess that you're going to give me an appearance for Smart. Go right ahead, sir.
Yes, Your Honor. Brian Kingsley, P31091, on behalf of defendant Smart. I agree with Mr. O'Connor's statements. There was some confusion in the previous proceedings and the transfer to 36th.
All right, so Ms. Khan, I suppose, let's start there, that you don't have an objection to the court conforming its file to the reality that there is a plaintiff here, tox testing lab, that has an action pending against the City of Detroit, the Michigan Automobile Insurance Facility, and Smart.
That's correct, Your Honor. Yes, I would be happy to have the order conformed to reflect the true parties.
So what the court, thank you, Madam Counsel, what the court will do, and Ms. Cobb, I suspect you're on the same page. You just represent the city, and you understand that there are a couple other defendants in this matter. Is that correct, Madam Counsel?
That's correct, Your Honor. At least at this point in time.
Yes, ma'am. So what I will do is I will sign an order conforming the file to comport with the true parties and their assignment of counsel with regard to these matters. All right, so that will put the thing on the proper nose that it should be in the proper footing that it should sit. All right, having said that, now all of the dynamics will be lined up where do we go from here? Are there issues of discovery that are pending? Was there a motion ruled upon, or is a motion yet pending? Somebody talk to me.
Your Honor, thankfully, Mr. O'Connor brought today's hearing to my attention because I wasn't listed on the court's notice because I wasn't listed in the Register of Actions. It appears that there may be on the court's docket Smart's motion to change venue. If that's the case, that motion would be moot because by the time I file the motion to change venue in 15th District Court, venue had already been changed or transferred to 36 based upon stipulated order between plaintiff counsel and the city of Detroit's counsel. So if you have a motion on the docket from Smart, that motion is moot and need not be considered. It's also my understanding from exchange of emails in the last, well, yesterday and this morning, that there's agreement that the underlying claimant, Timothy Gillenwater, was a passenger on a City of Detroit DDOT bus rather than a Smart bus. It's therefore my understanding that the parties agree that Smart may be dismissed from the case and that the dismissal would be without prejudice.
Let's start with this comment, that second part. Certainly any motion, regarding transfer of venue would be moot at this point. I was thumbing through. I thought at first I saw a motion for summary disposition, but I don't think I see that at this point. Is there a stipulation, Ms. Khan, excuse me, as it relates to Smart, that they should be dismissed on this matter without prejudice this time?
Yes, Your Honor, I have agreed to dismiss Smart without prejudice based upon City of Detroit's, my understanding that City of Detroit should be first in priority. So yes, I will agree to dismiss Smart at this time.
All right, I don't see any cross claims or third-party claims or anything, but anyone objecting to Smart being allowed out of this matter at this time?
I do not.
The city does not, Your Honor.
All right, very well. The court then will issue an order dismissing Smart from this matter. That dismissal will be without prejudice, without cause.
Your Honor, would you like me to prepare that order or will the court issue it?
The temptation is always to do it myself, but you know, we got two things that the order has to house, and that is the order aligning this case, and then secondly, dismissing Mr. Kingsley and his client out of this matter. If you want to take care of that for me, sir, that would be great.
All right, I will prepare the order and circulate it to council for review and approval.
All right, excellent. All right, Mr. O'Connor.
Yes, good morning again, Judge Coleman. Now that we're aligning parties and figuring out who may be who in the zoo here, if Mr. Gillenwater was in fact the City of Detroit bus, Smart getting out, and the City of Detroit, based upon the priorities, should be first in priority. Ms. Khan, do you have, I'm asking for dismissal of the MEIPF, even without prejudice at this time. If you do have a City of Detroit bus case, there should be no rhyme or reason that the MEIPF, kind of funny, we're just getting in again, but it should not remain in this case at this time. May I get your thoughts on that?
I think, Tim, if you wanted to discuss this after the hearing, that would be great. And if Mary Beth is on board with that, that would be fine with me as well. I'm not sure if you wanted to get the deposition of the plaintiff first, though.
We can continue to discuss that. I guess I was just asking, since we're talking.
What seems somewhat reasonable, well, what seems reasonable, but significantly it seems rational is that you hate to, well, the City of Detroit has to deal with this matter because it seems that there's a stipulation that a person was on a city bus. How we formulate then a claim that relates to the assigned claims facility. And excuse me, that I'm dating myself by calling it that, the assigned claims facility. I don't know, I don't know how you do both, you know. I don't know how you have both things going on. What would seem reasonable to me is that unless there is just something you have to press upon, that at this point, it would seem reasonable to dismiss the assigned claims facility without prejudice. And if they need to be brought back in, the dismissal without prejudice, a motion addressing with particularity why they should be brought in would bring them back into this matter and go forward from there. Now, that's what seems like it makes sense to me, and I don't want to, I know that the attorneys have their own thoughts about how to do this, but that's what seems like it makes sense here, to clean this case up. It seems to be that Smart should be out of this, and that the assigned claims facility should be out of it, again, without prejudice. And if there is somewhere along this grid that either the city or the plaintiff believes that the assigned claims facility needs to be brought back in, then you file your motion, and the court considers that, and you'll have the particularities to raise that issue at that time.
That makes sense, Your Honor. And like I said, if Mary Beth is okay with it, then I would be okay with dismissing you as well, Tim.
Yes, Your Honor, this is not the first provider case that's been filed involving the underlying claimant, Mr. Gillenwater. So the city feels comfortable if for that proposal for dismissal of the MAIPF.
Right, so
Thank you.
I'll grant the petition in that regard, and Mr. Kingsley, if you'll, you now have a third item to include in your order, if you will. And if you're afraid of it, I'll draw it up, but I'm kidding with you. But that's another piece. And again, that is without dismissal, without prejudice, so that if somebody sees somewhere along the line that that the court should pick this back up and deal with some other components, I'll address it at that time.
I'll try to handle that, Your Honor.
All right, sir.
May I speak up only because there's been so many changes here? Thank you, Ms. Khan and Ms. Cobbs. I think Mr. Kingsley had the same question, and I think the judge, and I appreciate the judge, you want to issue your own order. Mr. Kingsley was talking about an order. I would need an order. I just want, before we leave the Zoom call, is who's going to be drafting the order dismissing the MEIPF?
I'll put it all in one order.
Thank you, Brian. Will you send it over for sign off?
Of course, I'll send it to all council for review and approval.
Okay. Well, thank you. It sounds like we've accomplished quite a bit. Now, I guess you guys have to talk about moving forward.
Yeah, real good. You almost put a robe on that time. Thank you. But I'm sure, Mr. O'Connor, you don't want to take that pay cut.
No, Judge, you may not remember this, but I think at one point in time, we sat next to each other. We graduated in the same class about 34 years ago. So I'm going to let you do your job, and I'm getting out of the case. That's all I need for today.
You didn't have to tell how long ago it was.
It's like 34 and a half now, Judge.
It makes perfect sense because my daughter is 36, and
oh boy.
She was born while I was in law school, and of course she's the judge out at 32A District Court.
Oh, wow.
But anyway, thank you. That's a long time, man. Where did the time go? All right. Thank you, Mr. O'Connor. Ms. Cobb, Ms. Khan, any discovery issues at this point? What direction do you need from the court, if any? Let's try and see if we can go forward on this matter.
So thank you, Your Honor. So procedurally, when the city learned that this case had been reassigned to 36, we did just fax over our answer to the complaint yesterday, and the city will need some discovery in this matter, Your Honor.
All right, Ms. Khan, anything at this time?
No, Your Honor.
Right.
I will just wait for a scheduling order to be set in place.
All right, very well. So I'm going to go ahead now and set this on a 60-day discovery order. And I'm actually going to allow that to run through the date of the next hearing. So that's going to put this next hearing in the month of March. And my clerk is giving me a date in just a moment.
You want the middle of March?
Yeah, the middle to.
You want the 17th?
Yeah, March 3/17, 22, 3/17/22 at 9:30 a.m. And discovery is open through that date. The court is pretty liberal about allowing discovery opportunities so long as the parties are not abusive and so long as the parties are diligent. So I'll allow discovery to be open through that period of time. If you along the way have operated diligently and you find out that there is some additional time that is needed to complete some things, that we'll address that on the 17th. And that's usually something that will be permitted. But please work diligently to move towards the things that you believe that you need to get the job done in this particular case. Also, the court's order will provide that parties may file motions for hearing on the 17th of March, March 17, 2022 at 9:30. You may file motions and set them for hearing on the 17th. Those motions may be dispositive or non-dispositive. And as long as you provide at least 7 days notice to the opposing party, I will hear your motion. I know that shortens the time that's normally allowed under the court rules. So that if you file a motion for a motion for summary disposition or any other kind of motion, as long as you allow the other party at least 7 days to respond before the hearing date, I will hear the motion on the 17th of March. All right. So you'll get a scheduling order with that information in it, and the scheduling order will also have the new date of hearing. I know that you noted it, but it will be in the scheduling order. And any other issues of schedule, we'll address them on the 17th of March, 2022. All right. Anything else for the court at this time?
The pretrial is at 9 a.m. though, correct, Your Honor?
9:30.
9:30. Okay. Okay.
All right, good day to all. I await that order, Mr. Kingsley, and we'll get that all signed up, and then Ms. Khan and Mr. Cobbs, you'll receive the scheduling order regarding this matter. Good day to each of you.
Your Honor, Your Honor, what's the best method of getting that order to you? Filing it with the clerk's office, emailing it, or what?
Please email it. Now you peek into the temptation the court has in drafting its orders, because I can control it right here and get it right out. But here's the email address where you can get that to me. That's Latifah, LATIFAH @3636th districtcourt.org.
Thank you very much, Your Honor.
Thank you, sir. Thank you, Mr. O'Connor. Thank you, Ms. Khan. And thank you, Ms. Cobb.
Thank you, Your Honor.
Have a good day.
Thank you, everyone.
Bye-bye.
All right, this is case number 21-159-372. This is Progressive Michigan Insurance Company versus Cleveland Davis. The matter is before the court on an application for entry of judgment by default. The default in this matter was previously entered. The court established that service was made by alternate means as allowed by the court, and then set this matter for entry of the judgment. Your appearance, Progressive, at this time.
Your Honor, Jennifer Dillo, P69855, appearing on behalf of the.
All right, thank you, Ms. Dillo. Good morning to you, ma'am. All right, Cleveland Davis, or anybody representing Cleveland Davis on this Zoom, please say something at this time. All right, it appears that the defendant, although receiving notice from the court and having been noticed regarding this matter in the lawsuit that was brought, has not appeared regarding this matter of a petition for entry. Accordingly, the court now will enter the judgment by default on the terms as prayed, and judgment will be entered for the total sum of $16,013.69. It is so ordered at this time.
Thank you.
Thank you, Madam Counsel. Thank you for your patience. We are doing this a little bit differently. When there was a switch and we had to separate the default and the entry, I said, well, wait a minute, I'll set a hearing and you guys get to be the victims of those hearings. But in the future, it's just a 14-day notice, and if they don't respond, the judgment enters. But thank you for being here. I get to say Happy New Year to you.
Yes, Your
All right, the court now calls case number 21-16-1504. This is credit acceptance versus looks like last name is Arbor, Samaj Arbor. The first name is Semaj. Middle initial strike, that last name Yarver. That's what it looks like. This is a petition for entry of judgment by default. The court having previously entered the default of the defendant in this matter. The court noting that defendant was served in this matter, that proof of service was presented to the court. It looks like there was a, what is the service? Obviously, it's just a- All right, counsel, your appearance regarding this matter, I'm looking for, I'm looking for the service in this matter regarding Yarber. You may at this time. Counsel for credit acceptance. All right. There were two defendants in this matter, and I do have proof of service regarding defendant number one, it looks like, and that was with Latonia Hart. The application for entry of judgment was asked to Mr. Yarber. I don't have anything in this file showing service as to Mr. Yarber, nor do I have an order of alternate service in that regard. For that reason, the application for entry of judgment by default as relates to Mr. Yarber will be denied. I do see that there was an application for alternate service in this matter, but I don't see even a proof of alternate service. So the motion for entry of default judgment in this matter will be denied. Calls case number 21-162546. This is Credit Union 1 versus Chantel Smith.
Your Honor, I apologize. It looks like
application for entry of judgment by default in this matter. Your appearance, counsel, tell me which case you're talking about, if you will, sir.
Yeah, Your Honor, it was the last case. It looks like I was muted while I was trying to talk. I placed my appearance on the record for credit acceptance. I apologize for that.
Your appearance, tell us.
Yep. Good morning, Alexander Popov, appearing on behalf of Plaintiff Credit Acceptance Corporation, P84378. I have the signed order regarding alternate service. Was that what you were looking for, Your Honor?
I see that there was a petition for the same, but I don't see and I see that I signed the order for second summons, but I don't see any order or documentation that there was in fact alternate service. So before the court could enter, well, wait a minute, hold on a second. I see now, I am seeing something attached to that. I'm sorry. All right, so I do see now an order that seems like it was attached, not attached, but it was on the back of the judgment. It is an order regarding alternate service, and the order of the court was allowing service to be performed by first-class mail tacking and electronic certified mail, and that was November 24th, 2021. I don't have the proof of service in that regard. The counsel, you're indicating that the plaintiff carried out the service that was allowed by alternate means. Is that correct, sir?
Yes, Your Honor. I have the copy of the proof of service. It was done by a process server on the date of 10/31/2021. And it was notarized on 11/2/2021.
Okay, so what you need to do is to, I'll give you the email address to email that to me. That's okay. So no, I don't have that particular document in the file. Just making sure. All right, so you'll need to email that to me on the representation. On the representations of counsel, the court will now enter the judgment by default. The court has previously allowed service process by alternate means, and upon presentment of the proof of such service, the court enters the order in this matter. The judgment amount is $11,865.06. Any previous order that the court issued is hereby set aside. The default was entered on the 11th of December by the clerk. The court now enters the actual judgment based upon the presentation of proof. All right, so counsel, if you will email that to Latifah, LATIFA.Hunter@36districtcourt.org. Court will receive that for a file, and we will email you a copy of the judgment at this time.
Oh, perfect. Again, I apologize, Your Honor, about the Zoom issue there. That's my fault.
Well, you know, Zoom made good when things happen the way that they happen. But there are some glitches.
Yeah, for sure.
All the best, sir.
Thank you. Take care.
Take care, sir. I did call 2546 as a Suffolk Credit Union versus Chantel Smith. Your appearance at this time, counsel.
Thank you, Your Honor. Scott Renner on behalf of plaintiff.
All right, thank you, Mr. Renner. Good morning to you. I do see that alternate service was allowed in this matter, and by various means. And it looks like I received something indicating that that the service was completed by the alternate means that were allowed by the court. That's your understanding, is that correct, sir?
Yes, Your Honor.
All right. The court having previously entered judgment by default on this matter, or having entered a default on this matter, the court now enters a judgment by default where Ms. Smith has not appeared in the Zoom and has not otherwise responded to this matter. Accordingly, the judgment will be entered now for the total sum of $1,146.42. The court is signing the order at this time.
Thank you, Your Honor.
Thank you, counsel. Good day to you, sir. Who do I have as a court reporter out there? All right, how are you?
Good, how are you?
Good. Thank you for being here today. Thank you for helping us get through this.
Oh, no problem.
Stay safe and all of that, right?
Yeah. Oh, and Happy New Year to you.
Likewise to you.
Thank you.
Can you believe we're almost at half of the month already?
I know. I was thinking about that. Yeah. Yep, we're off and running.
Yeah, we're off and running already. We got to get it done, otherwise it's going to move on anyway, you know?